Hello, everyone, and happy Tuesday. We are, it is August the 5th. Can you believe it's August already? 2025. And we're going to continue today with our exploration of the Bill of Rights on the original 1787 Constitution. We can't learn enough about these. And when it comes to dealing with our international business assemblies, um, let's remember that this is about learning what side of the fence we're on. What did we give away in terms of delegated powers? What their obligations are to us in these Bill of Rights, to the employees, and where the fence is really drawn. So, as we go through this, I want you to keep in mind and keep associating these concepts of our 1787 Constitution and the Bill of Rights, the amendments to that Constitution, um, in terms of how they kind of negotiated our final, not really final, but the Constitution at the time. And it was really done to overcome some of the objections that were out there and bring on the additional states to really cement and ratify the Constitution, and keep it well standing. So today we've been through the first three, and today we're going to continue with the Fourth Amendment. So Anna hasn't joined us yet. Hopefully she's able to do that. I know she's very busy moving things around and doing the things she needs at home. But as Anna would say, usually I'm pretty well prepared for bear. And so we're going to go forward, and hopefully Anna can join us very soon. So I'm going to bring the Constitution and then the amendments up here. Let me slide through this here. All right. So, oops. All right. So the Fourth Amendment, which was really the sixth article that they wrote and contributed to the Bill of Rights, and that was Thomas Jefferson's coined phrase for these amendments, is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. We see that kind of trampled on today a lot. And so, we need to be really firm in our knowledge of exactly what that really means in terms of, what is the intent of our founders towards this particular amendment. So on here, let me find my notes. So that's not it. I went back too far. So here we go. All right. That's not right. All right. Well, so our founding fathers went through an awful lot in terms of being beset upon by the British regime at the time. And in this Fourth Amendment, they wanted to make sure that that people couldn't just be automatically searched upon. They used something. And there's a particular term for it. So let me get that. this. Okay. So the British had what they referred to as writs of assistance. And these were just kind of general, ethereal types of warrants that they used and gave to the British agents just to go search the colonists' homes and businesses. They didn't have any cause. They were just kind of searching around in the dark, just kind of poking to see what they could find. And they were very invasive. They were completely unchecked. They completely violated the privacy of the colonists. And in English law, um, these were considered the worst instruments of arbitrary power. They really ignited the revolutionary sentiment in people because they didn't feel like the police state, which is what it was, um, should have that kind of access to their privacy, to their possessions and their property. And so there were cases prior to 1776 in English common law that really established that the king's agents could not violate a person's privacy without lawful justification. Yet here they were in the colonies, taking advantage of the colonists um, in in their homes and wagons and personal effects. And really, what they were looking for was the roots of the unrest and the insurrection that was starting to happen because of the various other types of trespass that the British were actually causing on our colonies. And so, the founders felt that, when liberty died when privacy was surrendered. And so this became a very core value to the colonists and the founders of our great United States. And they really wanted to make sure that they enshrined those protections so that future governments couldn't just become tyrannical and under the guise of law enforcement. That applies to today, doesn't it? Where we see that becoming ever so more encroaching as we are out and about. Um, just the fact that we have to give up, when they insist that there's an ID. This is where our Fourth Amendment really speaks to being secure in our property, our papers, our effects. And so, you know, we need to understand this in terms of, our Fourth Amendment, the Fourth Amendment applies and it's rooted in natural law. This moral authority and the constitutional principles that we put forward in our original Constitution. It's really derived from individual rights and sovereignty. And, a person has a right to be secure in their home without intrusion. Um, and so something can be legal, but it's not necessarily lawful when it violates our privacy. And so when we apply this, we have to realize that the Bill of Rights doesn't really apply to us. It's about the boundary that we're identifying that applies to them. This is what they can't do. Our rights are natural rights. They're given by God and they're not to be violated at all. And so in our sovereignty, we have to realize that, there's the line drawn in the sand between their fence and our fence, so that, when it's applied, we understand that that's really the lawful. It's lawful in its spirit, and it protects our natural rights, and says, here's the boundaries. Now, a lot of people will say, well, but we gave that up to the states. No, the states of the corporation. And we find that many want to ignore the difference between the several states and the United States. So, this is where the line is drawn between the two in our sovereignty. And we say you have to have probable cause. So, what is probable cause? Well, that's kind of been eroded as well. They give up all kinds of excuses and um, you know ethereal kinds of causes and to try to gain jurisdiction. And when we say, oh, okay, then they just gain jurisdiction over us. We step over onto their side of the fence. And so, we need to ask them what their articulated probable cause is. And they have to have more than just a totality of circumstances that allows for a broader definition of whatever it is that they say. And so we bring up our Fourth Amendment rights when we're holding them to their boundaries. So, they have to we have to consent to those searches. Remember that we can only be governed as sovereigns by consent. That means we have to give that up. And if we don't give that up, they have no consent. They have no jurisdiction over us in our jurisdiction. It's where the dividing line is. So one of the big things you're going to see wrestled with in the future is digital privacy, because it's coming ever more so. A lot of people don't realize that cryptocurrency is based on your online data, your personal data being used for their personal gain. The Fourth Amendment would say, unless you consent, you can't use that. And so there's going to be coming down the line, I think, some very current, interesting cases that will happen over some of the consent. And of course, they don't give you a whole lot of option to use a service unless you give them consent over the ownership of your data. And this is one of the things that when we're reading the EULAs, the end user license agreements, that we need to be very cognizant of and read through, not just agree, unless we really don't care how they use our data and what data they're using. And we need to be looking at that very carefully, because that sometimes puts us on their side of the fence and takes away the privacy that we are due via our Fourth Amendment rights. So the Fourth Amendment is really about respecting the boundaries between individual and the state. And it affirms that you are sovereign over your space and that the government must earn the right to intrude. So they can't just presume it. And so one of the definitions I, kind of went out and researched a little bit further was, what does the word effects mean? What did our founding fathers mean by our effects? Well, effects refer to our personal property. It's the movable items that belong to an individual. And so that includes our clothing, our tools, our books, our furniture, even down to our cars, our phones, our computers, and then any tangible types of and intangible possessions that are not covered by persons in houses or papers. So essentially, all of the things of our life that surround us are basically the residuals of our effects or of our life, and the things that we can carry or store, use, that reflect our identity, our habits, and our choices. So sometimes, we're asked for our ID, we can give that up, or we can say, why do you need it? The Fourth Amendment says, I don't have to give it to you. I can be secure in my private property with my private possessions, which my ID is one of them. One of the things that people always, kind of point to and relate to this particular Fourth Amendment is the fact that, during the war in Europe, in Germany, it was, where are your papers? Give me your papers. And our Fourth Amendment right specifically says you don't have to give those papers to anybody. You don't have to ID yourself in any way. And it really becomes important in all of the things that we do, that we understand the context of what those effects really meant. So we go back into the founders and we talk about colonial America. The British agents used just general warrants to rummage through people's belongings. They didn't have any specific cause. The founders found that as a direct assault on their liberty. And so, it was with some of our founding fathers, John Adams, James Otis, that argued that personal property was an extension of one's personhood. That would be our natural personhood, right? And that effects was the word effects was deliberately chosen to cast a wide net, so that it didn't just protect just the homes or the papers, but it protected everything else. So you couldn't be stopped on the street and ask for your ID. A few years ago, New York had a stop and search, and it was shot down by the Supreme Court based on this Fourth Amendment, that we are secure in our persons, our property, our homes, our papers, and our effects. So you might ask, well, Lisa, where does that apply then? Why do I have to go to the airport and I have to have everything searched? Why do they have that ability? Well, first of all, you're on a federal zone. That means you're on their territory. Okay. And secondly, when we say, for example, go into a public event at a coliseum or some kind of a public house, or an area where it may be governed privately, then remember, they make their own law on their own private property. So we have to begin to be a little smarter about how we think about these things and relate those back to our Fourth Amendment. So, kind of I asked a little bit to do the little bit of research about what are the lawful and the legal implications, because they're different. The lawful applies to the sovereign and the legal applies to the corporation. And so it says that, in its philosophy, the effects are sacred extensions of personal sovereignty. And the legal interpretation says effects are subject to search if privacy expectations are reasonable. So reasonable has a very broad definition. And so if you get asked that and they use that terms, ask them to define reasonable. What is reasonable and what is not reasonable, right? These are the types of questions that we have to begin to ask and articulate and be able to stand behind when we're approached from that legal side of the fence. In its protection, the Fourth Amendment is and its effects are based on ownership and possession. This is why one of the comments that was made by Klaus Schwab about "you will own nothing and be happy" is so repugnant to Americans, is because we have a Fourth Amendment guarantee that for ownership and privacy of our possessions. So they have to get consent to search any of our effects. And so if you own it, it's protected. But if you leave it in the public, then it's been known to say that it was in the public, and therefore you left it and waived your right to the privacy. So it's really important that we comprehend what these concepts are, so that as we go out and about, that we can, basically give in or enact our natural rights to our privacy and to the ability to have them serve the Fourth Amendment. So effects are not just objects. They're basically a manifestation of autonomy. They're part of our sovereignty. And we're not, it's not just confined to our body or to a home, but even all the tools and the things of our daily lives. So every time this has come up, for the most part, the court has absolutely upheld our right to our effects. So, even down to, our car, a boat, a conveyance of the day. And that was a word that was chosen in some of the first travel cases that the Supreme Court handled. And it came out of Washington, state of Washington, where there was a very wise justice there who saw into the future and knew that the future would change. We would not always have horses and buggies and wagons. And he termed it conveyances of the day, whatever it is that transports us from one place to another. And so it then kicked in and had an effect even to this day over the things that we possess and that convey us from one place to another. Doesn't matter. Could be a golf cart, could be, our car, a truck. As long as we're not driving in commerce and we're traveling in private, then the Fourth Amendment actually applies to not having our conveyance searched. You own it, you control it, it contains your personal items, and it reflects your sovereignty, your autonomy, and your mobility, right? So it is an extension of your person and your property. And so it's covered under the Fourth Amendment. Where many of us kind of go wrong out in the traveling is we either get out of it, get out of our conveyance, we may be ordered out of it, we may be told it's going to get towed. Here the police state has gotten to the point where they'll even smash a window and drag you out over the broken glass. But the important part is keep the keys. And if they tow your car, when you give the keys to the tow truck driver, and you give them, not the police officer, because surrendering them to the police officer gives them consent. All these small little things that we do, right? You give them to the tow truck driver with the instructions that no one is to search the car and he is to keep the keys, right? You have retained consent at that point. And so it's really important that you are really knowledgeable about how broad this Fourth Amendment actually is. You're asked, can I see that? No, thank you. Don't have to say anything more, because consent is the key to retaining the ownership and control over our properties. Okay. So with, you know, they have done a few exceptions. Now, the legal side has done some exceptions. Doesn't mean that it necessarily stands up in court as long as you're able to defend it lawfully, right? So if they have probable cause, what is that? Well, they have more than two witnesses that identified your car in the middle of a crime. They have video. They have traffic camera, um, or whatever it is, private video that identifies your car. Then they have probable cause. And because we have that right to Hey everyone, sorry about that. I had a little internet outage, and so we'll continue. Let me set back up here because it kicked everything out, of course. So anyhow, it's really important. Is it muted? Can you hear me now? Say yes. So it's really that we are really um, aware of this Fourth Amendment and how it applies to us and how they are supposed to be servicing us through that Fourth Amendment. And so it's really important for us to really know what our rights are, because that consent is a highly important part of our Fourth Amendment. Okay, so that's really good news. And for those of us who, keep watching for and in our travels, we want to make sure that we're always very mindful about our consent and the fact that in our sovereignty, we are secure in our properties and our papers. So, um, thank you all. I appreciate you hanging in there. Sometimes my internet is a little bit funny. Um, so be very aware of the fact that we really have to guard those particular privacies that we have, and realize where those boundaries really lie. And again, thanks to Washington State, in the first challenges to travel laws, we can refer to those cars and trucks and wagons and whatever it is, golf carts and motorcycles and trucks and scooters. We can refer to those as conveyances of the day. And so therefore their vehicle, which is a legal term, does not apply to those conveyances of the day as long as we are traveling in the private and not traveling in commerce. So what does that mean though? What a lot of people don't realize what traveling in commerce actually is. So in the latter part of my career, I was a sales rep before I retired. And I hauled around in my car. I had samples. They were not samples to give out. They were samples to educate with, because that was my job. And so if I got stopped going from one place to the other, I was still traveling in private, but those items that were in my car gave them a little bit of pause to be able to say, you're traveling in commerce, right? And I have to explain that my job was education. I would show them sometimes that my samples were worn, and that way for demonstration purposes only, that I was not transporting goods in the car, or providing any kind of professional services in any way, right? But if I had product in my car that I was going to sell or deliver, that would cross the line, right? And I would be traveling in commerce. The other thing that we have to keep in mind is the modern day taxi, right? Called Uber and Lyft and all of those little services where we can provide, maybe it's DoorDash, where we deliver meals. Those are all commercial activities, right? And so there's a line between that and traveling in the private, okay? The minute we take on someone that pays for a ride, we're traveling in commerce. We're no different than a bus or a taxi, a train, or an airplane. So we have to be really cognizant of those different little nuances that throw us over into the legal jurisdiction. And remember, everything that we do in our assemblies is about jurisdiction. We have to think about what the boundaries are, what the fences are, right? And so with our Fourth Amendment, we have to be really, really aware that Fourth Amendment only protects our personal property. When we drop into commerce, we are no longer in the private. We are in the public. And that gives them the ability to almost, in a way, take away our consent, corporation to corporation. That's why they can charge the legal straw man, the all caps name, with um, with a fine or a charge, or charge against us. So you know our private cars, trucks, boats, etc., are in the lawful jurisdiction and in an original constitutional sense. And some of the legal doctrine um, has kind of eroded some of that protection in favor of state convenience. But the question you need to ask is which state? Because our state, is it our sovereign state, our sovereign people, or is it the legal state, the legal fiction? And so again, going to kind of influence the fact that this is about lawful versus legal, our lawful sovereign jurisdiction versus their contract legal jurisdiction. And we've referred again to the fact that the Bill of Rights is about how they are to treat us, whether we work for them or we retain our natural rights as sovereign people. And so the difference is that contract. Is the contract. Eventually, we're going to look at the 1790 contract and show you how this has morphed from our 1787 Constitution to that 1789 Constitution, and where that applies. But it really applies for them as employees to treat us in a manner that is suitable to our sovereignty. Okay, so that's pretty much, and that's the rub that happens between the sovereign people and the states of, and that many state of employees do not understand and will not try to recognize. And so the Fourth Amendment, if we find ourselves in their court, the Fourth Amendment can help us to be secure in our properties and in our privacy. Okay. All right. So enough about the Fourth Amendment. We're going to move on to the Fifth. And I'll read that out. So the Fifth Amendment provides that no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So this has some pretty broad concepts within the Fifth Amendment. And you hear people say, well, I plead the Fifth, right? And which means they're going to keep silent. They're not going to incriminate themselves, whether that's joking or in serious matters, right? And again, coupled with our Fourth Amendment, you don't have to give up that ID. If you've not committed any kind of a crime and they have no articulable probable cause, then you can invoke both the Fourth and the Fifth Amendment. Okay? And the Fifth Amendment kind of comes out of recognizing the English abuses to the people, and this happened long before America's founding. The English monarchs relied on courts of star chambers and high commissions, and they used coercive, inquisitorial methods to extract confessions without formal charges or defense counsels. They used torture. They used forced incrimination. They used extortion. And it was commonplace. And the defendants had no right to advance any kind of notice of advance notice of accusations or evidence. They just got grabbed. They got tortured until they would finally give up a confession of some sort or information, or they would implicate someone else in it in order to get out of whatever it was or gain some kind of immunity or a softer sentence or whatever. They were brutal. They were brutal. If you've never watched the series Outlander, it gives you a very, very good idea of exactly the types of torture and the types of star chambers that they used, especially against the Scottish people, that led to the War of Culloden. So, this is the Fifth Amendment is really a reaction to that. And colonial Americans recognized these practices as tyrannical, and they imported the English principle of nemo tenetur. And that means no one is bound to accuse themselves. And so they thought it was such a great idea that some of the original 9 state constitutions included this concept before there was ever any federal ratification. So this was, the ratification of the Fifth Amendment happened in 1791, and it became part of the original Bill of Rights. And so the framers kind of distilled centuries of English common law protections against compelled testimony, double punishment, arbitrary deprivation of liberty, and uncompensated takings, which is also a part of this amendment we'll talk about a little later. How do we equate that to today? Well, the minute they find out that you have changed your status, if they decide to hold you in contempt of court, many have reported that they put them in a solitary cell. Most of the time, that cell either doesn't have any kind of air conditioning in the hot summer where it's sweltering, or that cell may be freezing cold in the winter with no heat. This, the Fifth Amendment, is one of those things, one of those amendments that speaks directly to that violation of how they are supposed to treat us. And yet they still do it. They try to compel you to make a confession, to get out of that condition, out of that cell, into a warmer cell, or out of that particular confinement. It is a star chamber tactic. And if you find yourself in that situation, a lot of times they'll come by and they'll say, "Do you have anything to say to the judge?" And you can say, "Yes, star chamber and Fifth Amendment," right? Star chamber and Fifth Amendment. You are violating my rights. And it should be enough that if they take that back to a judge, the judge should be starting to think about what they do, because it takes them outside of the governmental immunity then, and it becomes torture. You can state that I'm being tortured by the cold. It is against my Fifth Amendment rights. And this is star chamber tactics. Okay. And so this is where this particularly applies. We have no obligation to implicate ourselves. We don't have to confess. And in some ways, they've set our courts up so that even a plea of not guilty is a confession of guilt. So understanding that in our Fifth Amendment, that's also where this lies. Americans are innocent until the court proves them guilty. But if you walk into one of their administrative courts, what they do is they offer you a plea of not guilty, no contest, or guilty. Most people go, "Well, I'm not guilty." No, you're innocent. Because when you plead not guilty, you're essentially saying to the court, I have to prove my innocence, and you're right, I'm guilty until I prove my innocence. Otherwise, it's under I'm innocent. The difference is that we have an obligation. The court has an obligation to prove our guilt. And if they can't do that, then we're innocent. Okay? So this is where this really becomes convoluted, and we have to begin to think about the larger implications of not just implicating ourselves or our loved ones, but how the court handles that within the court itself, the de facto courts, and how they're supposed to treat us within this. So this also kind of locked in some safeguards to our American justice system that they would be very happy to overflow and do still. So these safeguards they're required to have a grand jury indictment, especially for capital and infamous crimes. Okay. So for capital and infamous crimes, they're supposed to have a grand jury. Now, one of the things they've done is made that super secret, right? So that does not give us the ability to see what kind of incriminating evidence they have against us. And so it is our responsibility then to be able to disprove in many ways or point out the manufacturing of evidence when it's in the court, or the incompetence of certain law professionals and law enforcement in order to prove our innocence within their court, or demonstrate our innocence is more like it. Okay, to demonstrate that. We have a protection against double jeopardy. So what is double jeopardy? Double jeopardy means they can't try you twice for the same crime because they didn't like the outcome of the way the first jury took it and did it. Many times they will say, well, we'll just have a bench trial, right? You say, no, I'm guaranteed a trial by jury. And there's a difference. And we need to learn the difference between trial by jury and jury trial. A trial by jury imposes the burden on the court to have people who are our peers. That's not only community peers, but it also means that it is political peers as well. And they know that. And they still tread on that. And they'll say, well, I'm going to have a trial by jury, or I'm going to have a jury trial. It's the same thing. No, it's not. And you have a right to go into that jury trial and impeach every juror that's there on the record. For the record, are you a U.S. citizen or an American? Right? Because it is a flaw in the court that proves that you have jurisdiction over what's going on. Even if the judge tramples through and says, oh, well, I have jurisdiction. Denied. I have jurisdiction. There are subtle things you can do that you may lose in that round. But when it goes to appeals in their court, you'll win in that appeal. We have to be smart about that. And that comes in with double jeopardy. Then they can't come back to us and say, oh, I don't like the way that jury voted, so now I'm going to try you again for the same thing, right? And then there's privilege against self-incrimination. I don't have to say that I'm guilty. I don't have to say necessarily I can claim I'm innocent anytime. Okay? I don't have to grovel before a judge. You should be groveling before me. I'm the sovereign. He's the basically servant. Okay? And then we have a guarantee of due process of law. What does that mean? What is due process of law? Well, the due process of law means there is a prescribed way that our affairs are heard, and there is a prescribed way that 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 there is either precedent, or it goes back to natural law, our Declaration of Independence, our Articles of Confederation, or our constitutions, or the Ten Commandments. That's the real basis of law, is there in the Ten Commandments, especially the last 5 that attend to us, to the affairs of man, not just the affairs of God. Okay, how we treat each other. And so due process of law is that all of those things are looked at, considered, and that we make sure that the voices are heard. They violate due process of law all the time. And you have to, if you find yourself in their court, then you have to be able to be watching for those small things and call them out and object and put it on the record, right? And then there's what they call the takings clause within the Fifth Amendment. So what is the takings clause? Well, the takings clause is about giving you just compensation for your private property. So when they seize it, they have to give you just compensation. So how does that apply? Well, if they decide they're going to put a road through, they can't just take your land and say, sorry, Charlie, we're taking your land and we're putting a road here. That happened in some of the early circumstances of our country, especially in the industrial age, where they wanted to give them pennies on the dollar for their property. And there were quite a few law cases that went to that because they argued the common good of the public on that. And the courts still struck it down and say, no, according to the Fifth Amendment, you have to pay them for the going rate of whatever it is. You have to provide that to them for their property. So that really speaks to our individual autonomy and our sovereignty. So lawful government recognizes that if the public needs private land for roads, schools, utilities, that it has to pay for a fair market value. And it assures that no one person, no one man or woman bears a disproportionate burden for society's collective needs. We need, in most cases, we needed roads at that time. We needed to be able to put through public utilities, railroads, schools on property. And so we had to do that in a way that was measured and metered and lawful, compensatory to the people that were taking that property away from. So the Fifth Amendment really isn't like a laundry list of courtroom rules, but it's really a declaration that you are a moral center, okay? And any interaction with the government, okay? And it insists that the authority be earned through transparent and fair procedures rather than presumed by power alone. Absolute power corrupts absolutely. And that's what we have to guard against within our courts and within our system of law. Okay. So, again, our Fifth Amendment isn't just about the right to not incriminate ourselves. It's also a protection for our property and just compensation. Okay. So, realize that, all of this was born out of the English abuses, star chambers and high commissions, royal courts of torture, essentially, secret proceedings, forced confessions. They practice, the practices were condemned as arbitrary and despotic, being a despot. So, and again, the term that was used by the colonists was nemo tenetur. No one is bound to accuse himself. Okay, it's a good phrase to kind of jot down and provide. So we have many protections in the Fifth Amendment, and there were some famous cases based on that. Miranda versus Arizona, 1966. Everybody's heard of Miranda rights here in the United States, although it's no longer something, one of the things that I hear all the time is, who is Miranda and what is, what are her rights? Why do I need her rights, right? Because I'm a sovereign citizen. I'm a sovereign person, man or woman, not a sovereign citizen. And I'm sovereign. And therefore, I don't need someone else's rights. I have my own unalienable rights. Okay. But it did reinforce the natural law and principle that no one can be coerced into self-incrimination. Okay. So, it was the right to remain silent. Anything you say can and will be used against you. And you have a right to an attorney. And if you can't afford an attorney, then one will be appointed for you. Right. Well, I don't want an attorney either. They're just there to attorn you, which means to turn you over to the court. Okay. So language, jurisdiction, jurisdiction. And then, of course, there's the famous case of Kelo versus the city of New London in 2005, where the government tried to invoke an eminent domain to take private property for an economic development that was deemed to serve public purpose, provided owners received just compensation. So there's a little bit of contention over that one, though, and lawful contention, because it expanded the idea of public use to include private development projects. And so, that's something that we have to push back against, because their economic development can produce much, much more than what just the property is valued out, and deprive us of our property. So those are some of the pitfalls that are there that we need to continue to watch for, as and hold them on their side of the fence when it comes down to it. So again, the Fifth Amendment guarantee is that no person shall be deprived of life, liberty, or property without due process of law. And so that expands way on beyond a courtroom testimony, but it does apply there. And it's about civil asset forfeiture, even down to digital surveillance and grand jury secrecy. Okay. So, once we're aware of these things, then we really have to continue to guard on that and be smart about that. If we find ourselves in their clutches, then we have to know these things to hold them to their side of the contracts, right? I'm sure the Fifth Amendment is going to be more tested in the future over takings, and a lot of that will probably involve our digital presences on the internet. It's also one of the reasons why you need to be very careful about what you put on the internet, right? And how you present that, because that is in a public space, and therefore it could possibly be used against you as evidence, as indictment, as probable cause to pull you into one of their grand juries. So you have to make sure that as you go forward, that you're thinking about all of those things in context. Okay. Well, I'm going to quick look and see if there was any questions anybody has for today. And let's see. Okay, make sure you're putting your questions in caps. It's tough to see. All right. All right. So, can arbitrary law, okay, I'll show this. Can arbitrary law be explained as part of maritime jurisdiction? Well, even in their administrative court, which is different jurisdiction, different from the lawful jurisdiction, then arbitrary is one of those words they do not like. When they're being arbitrary and capricious, meaning they are trampling over the concepts. So even in maritime law, remember, the basis of that maritime law come from common law concepts of after feudal England. And so they have certain things, as you can see here is what I presented in the history of some of these items, that arbitrary, they cannot be arbitrary. They have to have some evidence, and they have to have causation. And so you can call that out as arbitrary and capricious. And they would have to step back away from that arbitrary law to provide context to whatever it is that's struggling with. Okay, so that's a real important. That's a term that lawyers first learn in law is arbitrary and capricious. Okay, and it's a impactful charge when you make that. Okay. Let's see what else. Dorothea, can a person be a living woman or man and act on the maritime jurisdiction, like going with law of the sea while they are sovereign? Well, we do have some common law that applies in maritime. I'm not an expert at that, and I don't know a whole lot about that. Mostly it applies to commerce. Okay. And the law of commerce in terms of common law. But be aware that when you are in maritime jurisdiction, you're in their jurisdiction. You have to play by their rules if you subject yourself to that. Okay. And so, again, you have to feel for where those fences are. Good fences make good neighbors. And when the neighbors overflow their fences, it's time to penalize them in some way or another, right? And so we have to realize that anytime that we step in, I have a lot of people who, when they first change their status, they go, well, I'm gonna go here and I'm gonna demand this. I'm gonna go to the airport and I'm gonna demand. I'm like, no, you can't demand anything, because you are stepping into their jurisdiction, the federal zone, the maritime jurisdiction. And when you're up in that airplane, you are in the air jurisdiction. Okay. And so we have to be cognizant of where those jurisdictions lie. There are hundreds, if not thousands, of jurisdictions. So be real cognizant about the fact of where you are and what jurisdiction you are currently operating or standing on. Okay. So yes, there is some, but I am not all that familiar with it, so I can't speak to it. So maybe at some point we'll get into that, and in some point with Anna, and we can get more into the law of merchant law of merchant law of commerce in the common law jurisdiction. And so, so that's kind of it for today. I hope that this was helpful to you. I hope that, we all learned a little something from this, and we'll continue next week. And hopefully Anna will have the ability to join us. If not, I'll do my homework. So thank you all so very much. I appreciate you coming. Don't forget to like and share, and get out there and use some of these for outreach and your own assembly education. So we'll see you next week. Thanks very much again.